25. We're hearing the matter of the appeal from John Berryhill and others regarding a land use application approved by Cache County. We also have the applicant here as well, Finding Hope. By way of introduction, my name is Rob Patterson. I am an attorney. I have been hired and appointed by Cache County to serve as their land use hearing officer. So I get to hear these appeals and weigh everyone's arguments and make a decision ultimately. We're not quite as formal as a judicial proceeding, but we will somewhat proceed in that manner. We will, by state law, due to recent change, these types of hearings are hearings open to the public, but they are not public hearings. So we will have arguments from the attorneys from all the parties, but we won't have it open to the public to comment on it. So I won't make that time open to you. I'm sorry if you don't like that. You can talk to the state legislature. In terms of process, we'll just begin normal appellate procedure. We'll have the appellants begin. We'll hear from the county and then from the applicant, and then let the appellants have the final word. I will interrupt you and ask questions. I like to get clarification on things and make sure I understand your arguments and positions. There are two related decisions at issue in this appeal: the zoning clearance and the reasonable accommodation granted for the residential facility. Just say, by kind of setting the stage, I've read all the briefing, I've read the decisions multiple times. I'm formulating my thoughts. I have not come to a final decision. I'm excited and eager to hear everyone's arguments and presentations today. As I understand it, you're welcome to make the argument you wish. I will kind of highlight there's a few areas that I see as really crucial, and you're welcome to point me in directions you think I'm missing. But it seems like one of the primary issues is the number of residents, the number of 16. It seems like we have some evidence about, larger numbers are good, but how did we get to that exact number? Are there sufficient findings? Are there evidence for that? And so that was central in the briefing, so that's obviously an issue I'd want everyone to address. The other issue, I have some other questions, but they'll just come up as we have the argument. So I know that's going to be a key issue, so I just want to make sure everyone, please hit on that, because I need to understand everyone's position on that. So with that, I'll turn it over. Actually, let me ask everyone to kind of introduce themselves and state who you're representing, and then we'll turn it over to the appellant.
Taylor Jones representing the appellants.
Andrew Train with Cache County.
Dan Bidoff representing Finding Hope.
Thank you all. And Mr. Jones?
I'll be over here.
Please.
Okay, thanks for taking the time to accommodate us today. As you stated, we're here to appeal the county's decision on the reasonable accommodation, granting that request for 16 people to live in the home, and the approval of the zoning clearance. I'd like to first address the accommodation request, and then we'll get into the zoning clearance a little bit in just a few minutes. The appellate authority's task is to decide whether the county's decisions were illegal, arbitrary, or capricious, and the code defines that also as, well, capricious at least, as unsupported by substantial evidence. Under Cache County Code 171650C, any accommodation must be based on evidence of record showing, among other things, that without the accommodation, persons with disability would be denied an equal opportunity to enjoy housing, and the granting it achieves equal results between the disabled individuals and non-disabled persons. The county's decision here does not meet that standard. It cites house size, bedroom count, and lot size, but it never ties those factors to a disability-related barrier at this address, and never explains why 16 residents are necessary to overcome such a barrier. There's no finding and no evidence of record showing that a smaller number, whether that be 5 or 10 or 15, would deny equal opportunity, or that 16 is the minimum effective number to remove a barrier. On that basis alone, it is the appellant's position that the appeal should be granted. Rather than addressing those evidentiary deficiencies, the county in Finding Hope attempt to reframe the issue. They argue that discrimination is wrong, which is true, that the house is large, which is also true, and that peer support aids recovery, which is again true. But from those general truths, they make an unsupported leap, asserting that discrimination will occur unless 16 residents are allowed. They make that claim without any supporting evidence.
Just to clarify that, I think they did point to a couple pieces of evidence, so I'd like your take on it.
Sure.
There is one piece of documentation they both pointed to that talks about, for most effective treatment, we need at least groups of 15, or about 15, I think was the language, but no more than 20. And then there's another one that talks about, because when you have a transitional population, you want to aim slightly above, 1 or 2 people above the minimum, so you can maintain the minimum kind of critical number at all times.
Sure.
Do those address that issue? If say the number is 15, because that's what one of the pieces of evidence talked about, they say, okay, we need 16 so we can have at least one more, so as people transition in and out, we get 15 at least.
Sure. Yeah, there's a couple problems with that argument. First, the document they cite doesn't deal with housing at all. It just deals with therapy groups. Therapy in this situation, at least for a high percentage of any therapy that it's occurring, is occurring off-site, not in the home. So therapy doesn't have any application to the housing. Also, if I remember correctly, that one document stated 15 or less. 15 or less definitely doesn't show that 16 is necessary or is the minimum number they need. 15 or less could include, 5 or 10. There's nothing that says that they need 16, and their responsibility is to show that 16 is what they need to avoid discrimination, and that just hasn't been done. So on that, to that point a little bit more, the county is required to base its decision on record evidence of an actual disability-related necessity for 16 people at this address. It did not. It instead applied the wrong test, treating the home's capacity as necessity, and approved the maximum head count without the individualized proof related to this actual property. This approach does not equalize opportunity between disabled and non-disabled individuals. It instead creates preferential treatment in violation of the law. So I'd like to address the necessity and reasonableness issues in a little bit more detail. Both the Fair Housing Act and the county code demand an individualized showing that the requested accommodation is necessary to afford equal housing opportunity, not simply desirable or consistent with the provider's preferred model. The analysis there begins with a neutral baseline. The neutral baseline here is that 4 unrelated individuals are permitted to reside in a home. That's very clear in the county code. And once you get to that baseline, the proper question is, do persons with disabilities face a disability-related barrier at the baseline, so at that 4 unrelated person baseline? And if so, what's the smallest effective increase needed to remove the barrier at this property?
So I have a couple questions on that.
Sure.
I think, do we need a specific finding that says the 4 unrelated person standard, which is common basically everywhere in Utah and in the United States, is a barrier when we have it seems like almost at this point, these types of facilities have operated and generally always seek some kind of remedy. Do we need a specific finding that says, despite the dozens and dozens of federal court cases that litigate, how many people can we have in a facility like this, we need to specifically say, and 4 is a barrier to that? Can we just assume that? We know that, or do we need to specifically spell that out?
I think the law requires us to spell it out. It requires it requires the county to show by evidence how there's a disability and how the requested accommodation will remove that barrier.
Okay.
And I don't think that the county never does that in its finding. It jumps straight to 16 residents based on broad statements like, isolation is the enemy of recovery, and the house has many bedrooms. But the law requires site-specific evidence showing that smaller numbers would fail to provide equal opportunity.
Well, that's the other question I have. You mentioned it seemed like some kind of standard, but I didn't see a citation for it. The kind of least impactful change necessary to accomplish the removal of the barrier. Where does that come from? Where does that standard come from? How do I find that and apply it?
Well, I think if that wasn't the standard, the appellees could request any number. They could request 100, 1,000. I mean, the county's required to remove the barrier, not to remove the barrier plus provide additional.
Well, theoretically, they couldn't get 100. I mean, there's two tests. There's reasonableness.
Sure.
Theoretically, 100 people living in a single-family home, you can't really equate that to be reasonable. You know, it then starts violating the spirit and the intent of the zoning ordinances and all those provisions there.
Sure.
But on necessity, is there something inherent in that necessity element that says find the least change, but no more than that?
I think that's the very definition of necessity. If they need 16, then that's necessary. If they don't need 16, then it's not. If they could remove the barrier with 6 individuals living there, then 7 is not a necessity anymore. 8's not a necessity anymore, and 16 definitely isn't. So they have to show what they need to do to remove the barrier, and once that occurs, there's no more necessity.
I guess my question is, could they say there is a range? It's 14 to 18 people we know will accomplish this. And that's the range that is necessary, and so we're going to pick something in the middle. I'm not saying they've shown that, but could an applicant show that? You know, they have studies that say, you know, we have larger groups. We know 6 doesn't work. That's not good.
Sure.
8 to 10 works, and so they want 9.
Sure.
Do they have to show it's exactly 9, and we have documentation of that? Or can they get by saying, there's some critical mass in this range?
Well, I think the response is, if 8 to 10 can remove the barrier, if 8 can remove the barrier, then that's where you stop. You don't go to 9 just because it's in a range. If 8 can remove it, then your analysis is done. You don't keep moving up the chain.
Okay.
So it's important to note that the county's decision does not actually address these issues. Finding Hope's own material confirmed the gap. As we discussed a second ago, the overwhelming majority of the documents attached to their request discuss therapy group dynamics and not housing occupancy. One source mentions potential benefits around 8 residents, but none proves that 16 are necessary at this address or that smaller numbers would fail at this site. So while the county cited capacity, it never established necessity. This is the critical flaw, as courts have consistently held, and we cited several cases. An accommodation must be necessary to achieve equal housing opportunity. It cannot simply be helpful, convenient, or economically preferable. So in summary, I guess, capacity does not equal necessity, and the record contains no proof. The county doesn't rely on any evidence to the contrary, and because its decision failed to do so, it's our assertion that its approval was illegal, arbitrary, and capricious and must be overturned. And our analysis of the reasonableness issue is somewhat similar. Under 1760-50 C3 of the county code, an accommodation must be reasonable in light of legitimate zoning purposes. This means it must afford equal opportunity without fundamentally altering the character of the neighborhood. Here, the proposal would change the nature and scale of this small rural subdivision. I mean, currently there are only 19 residents that reside along this narrow dirt road. Adding 16 residents plus staff, plus deliveries, plus whatever else they need to run this place would more than double the adult population using the road.
What evidence is there in the record of the supposed change in impact, that there's going to be a change in character of this neighborhood? I
suppose that's one of our issues, and it kind of cuts both directions, is we were never made aware of this until these decisions were issued, or at least everything was submitted. So we didn't have an opportunity to add things to the record. But to that point, there's nothing in the record that shows how this will not impact the nearby residences. I mean, I know that there's some assertions that there won't be additional cars using the road and those types of things, but there's no evidence besides these unsupported claims. There's nothing in the evidence to actually rely on.
So that does raise an interesting point. The applicant has, at some level, a burden of proof with any land use application to present the information to justify approval, but the county and every other land use authority by state law is essentially required to approve any land use application as long as it complies with code. So
Yes.
I don't think there's a code requirement that says demonstrate there is no impact. I guess your kind of argument, I guess, would be then it's inherent in the reasonableness. They have to demonstrate that.
Yeah, and
Perhaps, maybe I'm not stating that correctly. What are your thoughts on that?
I think I just need to look at the actual 1650. It says, section C, the land use authority shall render a decision on each application for reasonable accommodation within 90 days. The decision shall be based on evidence of record demonstrating all of the following. And there's the three issues that basically follow the reasonableness and necessity requirements. And so we're just saying that there's no evidence that's relied on, and this county is required to rely on actual evidence showing that this is reasonable.
I think, so the findings, the interim director does find the requested accommodation will not undermine the legitimate purposes of the existing A10 zone, and has several bullet points talking about it's off it allows for this with a zoning clearance. The structure, this was kind of your capacity discussion. It's a large structure, 8,400 square feet, 10 bedrooms, 6 bathrooms, on almost 3.5 acres, with ample parking. Majority of residents won't even have their own vehicle. I think at some point talked about the county engineer looked at it and said it wouldn't have a significant traffic impact. Is that not evidence that this would not undermine the integrity or intent or purpose, spirit of the A10 zone?
That shows, that information, I guess you could say is evidence, or at least an assertion. I don't know where the actual evidence is, but an assertion that it would fit on the property. It addresses the capacity issue, but it doesn't address at all how it will impact the neighbors, how having all these additional people living at this property will impact the number of people that use the roads, the number of people that just live in this rural community. So I think the problem is the county repeatedly addresses capacity, but not reasonableness.
But isn't capacity, I guess, we're arguing a little bit over words, but isn't capacity related to reasonableness? There was one of the cases I think you cited where it was like a small structure that had 8 residents in a residential facility, and they were trying to go to 16, and the court denied it, and it got upheld. The denial was upheld because it said you already have traffic problems, you already have congestion, there's no place for you to expand because you don't have the capacity to add these residents in without significant impacts. So it seems like this is related to that kind of analysis of saying, we've looked at the roads, we've looked at the property, and there's space for those people without having them encroach on property that isn't part of this facility. Or am I wrong on that?
Well, I think it can be part of the decision, part of the analysis. I think where it's lacking is it just doesn't address the impact that this undoubtedly will have on nearby property owners. And there's no evidence showing that there won't be increased traffic. There's then again an assertion, but where's the testimony? Maybe I'm focusing too much on what actual evidence is in a courtroom, but
maybe that is the distinction, because I see here, the county engineer reviewed this and determined that the trip generation would be similar to that of a residential single-family home of 10 trips per day. Parking study isn't required. There will not be increased traffic generated for the proposed use. Some level, there's evidence and there's evidence. There's courtroom evidence, and sure, an assertion wouldn't meet that. But in the land use realm, can the county not rely on county staff and their expertise to make a determination on that?
Well, I guess I'd say the county staff has to make a determination based on actual evidence and not just assertions of the applicant. And we believe that having 16 people at this place with staff, with whatever else they need at the property is much more likely to increase the use of the roads than Finding Hope is claiming. I guess our point is we don't believe it's reasonable to go from the baseline of 4 to 16, a 400% increase, without there being a lot more evidence as to how that's going to impact the nearby residents. I mean, what's the point of having the 4-person requirement if we're not going to have, it's not going to be difficult to increase it by 400%. It's a big increase.
Let's say there was some very clear evidence, whether there is or not. Let's say there was, a study that says in rural counties, if a residential facility must have at least 16 residents in order to be successful in terms of, patient outcomes and all those things. We had that evidence in here. So necessity was taken out of the picture. It was clear, yes, we can get past necessity.
Okay.
And I'm not saying I'm just kind of take this as a hypothetical.
Okay.
Would they need to then show more for reasonableness, just other than to say, and the property can support it? We have room for it. They're not going to do more than that.
Definitely. Yeah, you have to show how there needs to be evidence that it's not going to negatively impact the nearby property owners. The subdivision, the very purpose of the zoning.
It seems like it's not really impact on property owners. It's undermine the purpose and spirit of the zone. And I don't know that those two are synonymous. Or are they?
If they're not, they're pretty close. I guess they're not synonymous, but the purpose of the zone is, the purpose of the zoning standards, I would argue at least, is to protect the people that live there. And if you're ignoring those or disregarding those requirements in a way that ends up negatively impacting the people that live there, I think it's problematic for multiple reasons.
Thank you. I think I've gotten your point.
Okay. So just to close up the reasonableness argument, I realize that Finding Hope is asking for, they'd like to use this for residential purposes. But it's our belief that a 16-person staff-operated facility introduces an institutional intensity that's not residential in nature, and that cumulative impact fundamentally alters what the zone is intended to be. So there does need to be a balance between how you help these individuals and what's actually reasonable, and it's our assertion that a 400% increase is not reasonable. A final point on the reasonable accommodation issue has to do with the comparator. Finding Hope urges the county to use the wrong comparator, comparing disabled residents to a hypothetical 16-person family rather than to unrelated occupants subject to the same 4-person cap. Equal result means removing barriers imposed by the unrelated person rule, not guaranteeing parity with an unrelated family size that the code treats differently. Using the wrong comparator inflates the analysis and converts equal opportunity improperly to preferred treatment again, which we believe is the wrong way to do it. So do you have any more questions on that? I'll plan to move on to the zoning clearance right now. There are a few issues I'll discuss at the end that I think impact both the zoning clearance and the reasonable application issue.
No, that sounds great. Thank you.
Okay. So because the reasonable accommodation approval is defective, the zoning clearance necessity fails as well. But even standing alone, there are multiple reasons why the application fails. The first is sequencing. The code specifically requires that a reasonable accommodation determination be made and supported by evidence before any zoning clearance or occupancy authorization is granted. This ensures the county exercises zoning authority only after an accommodation exists. Here, the county issued the clearance before approving the accommodation, which is a problem in and of itself. But also, if you go down to, you go to County Code 171640, it specifically states that a facility of this type must have, before a zoning clearance is approved, a valid residential license and a site-specific business license for this specific address. These are prerequisites and not just approval paperwork. The code explicitly requires that they be obtained prior to the issuance, that's a quote, prior to the issuance of a zoning clearance by Cache County. Finding Hope still does not hold either license, is my understanding. In its opposition, it asserts, quote, that the county does not require a completed license as a condition precedent to reviewing or conditionally approving a zoning clearance. That statement just isn't true. The ordinance's plain language imposes a clear prerequisite requirement. The county tries to get around this by adding a condition to the zoning clearance that certain fire and septic related issues be resolved prior to business license approval, but that condition does not satisfy the requirement that the licenses themselves exist before the zoning clearance is issued. The licenses are not just clerical in nature. They are a mechanism by which the county verifies that a facility meets all state and local health, safety, and operational standards before occupancy is authorized. And by skipping that, the county eliminated the procedural safeguardment to ensure compliance. I don't think it's appropriate for the county to just say multiple times here that, well, maybe we didn't follow the code, but what's the harm? I mean, the code exists to protect all individuals, and it really needs to be followed.
So kind of on that point, is there not like almost like a harmless error type? Say the zoning clearance, it was issued prior to the reasonable accommodation. If we had just started where we were at the beginning with just the zoning clearance, and I say, yeah, you can't issue that because you don't have a reasonable accommodation, and I deny it, then they'd go back and make a reasonable accommodation determination, and then
Sure.
we'd still, it seems like we'd be in the exact same place.
And maybe you would if that was the only issue. But the fact that you don't have licenses, those still don't exist. The law is very clear that they're required before the approval.
Can the county issue a zoning clearance that says something along the lines of, this is conditioned or won't be effective until, and has conditions where those things would be met? Because I know sometimes, just as practical, getting timing of licenses is hard when sometimes the state wants the local government to approve before they issue, and sometimes that sequencing gets difficult. Would a conditional approval work?
I'm not an expert on the sequencing. I mean, arguably it could work, but I don't think it complies with the law. But that situation isn't what occurred here. The approval did not say you're approved once you get licensing. It just approved it and says that you need to do certain things before licensing, but it's not conditioned upon actually obtaining the licenses.
Those were my questions on that. So yeah, it looks like we have a few licenses that are required. So certified copy of the license or an application for Department of Health and Human Services, so registered with the state. And then an affidavit about the threats and people will meet the standards. An affidavit that all current residents qualify, future residents will qualify, and then a business license if required. It sounds like a business license is required in this. But your argument is, even if it essentially the zoning clearance didn't condition itself on you can't have this approval until you go get a license and do these other things. They just said, go do those other things now. Is that summarized correctly?
Correct. I mean, that is a correct summary. I also think it's important to have the license before approval so the county can be sure before approval that all these other issues, some of which it addressed in its approval, are satisfied. Make sure that you're actually taking care of issues related to the health and safety of nearby residents when you have this many people living in a property.
Okay.
So a few issues that I think address or are related at least to the reasonable accommodation and the zoning clearance. One is the parking analysis. I mean, Finding Hope correctly points out that you only need a parking analysis if more than 5 spaces are required. And the code states that for single-family homes only, I mean, there's not more than 5 required. But I think we have an issue here in that we're going above what's actually, if we're going above what's permitted, which is the 4 unrelated people, if we're increasing that by 400%, we can't just ignore the parking issue. We can't just ignore the fact that when that many cars or that many people are living there, parking analysis is typically required.
So maybe, so a single-family home doesn't require a parking analysis, and is there a county code that requires specific number of parking spaces for a residential facility? Is there some code standard for that?
I don't know.
I wasn't aware of one, so if someone could point one out to me, you're welcome to do so. I don't think, I couldn't find one, so my question then is, if we don't have a requirement that says you must provide X spaces per Y residence, 1 space for every 3 residents, or some standard like that, it seems like instead of requiring an analysis, the county just needs to look at it under the reasonableness standard of, will this have a drastic impact on the neighborhood? And we did have a finding, it seems like related to that, where the county engineer says, we're not going to generate unusual parking. We have 15 spots. We don't need more.
I guess my point is that if a parking analysis, I mean, it's most likely undisputed. I don't know if it is, I guess, but if in any other situation where you're not requesting a reasonable accommodation, if you're having 16 adults live somewhere, you would need more than 5 parking spaces and you would need a parking study.
Yes, because it'd be some kind of multifamily use, I would presume. That's the only way you'd get that many people living in a place, or some kind of commercial institution, and presumably there would be a parking standard for that. I would say, X spaces per Y resident, or per square footage, or something like that.
So a parking analysis would be required in that situation, and we believe that because this is in essence the same thing as that, I mean, it's kind of an end around to get to the same thing, that a parking analysis is also required under the code.
Yeah, I think it's a good point, and I'm just trying to work it through in my head, because part of the issue is also the county cannot require of a land use applicant something that's not in the code. And so I'm trying to reconcile those 2 factors. I think it makes sense kind of intuitively. You have 16 people plus staff coming in. We should make sure there's enough parking for that. On the other hand, the code very specifically says, shall be required for when a use has at least 5, I forget what the standard, but it was requires at least 5 parking spaces. And there's no tie between those 2. Like, there's no requirement specifically that says when you do a residential facility, you must provide at least 5. That would then trigger the analysis. That's where I'm struggling there.
I think I look at it, I negotiate development agreements quite often with counties. And if someone's looking for some type of conditional approval, the county often puts additional requirements on that aren't in the code because you're asking for something that's not typically allowed. Here, where they're asking for 16 people accommodation, I think it would be reasonable and necessary to say, well, typically when we have 16 adults live somewhere, the law requires us to have a parking analysis. You need to do that here because you're asking for 16 people to live there.
I think I take your argument. Thank you.
And I think my argument is, I mean, almost identical with the International Fire Code requirements. So I don't know if I need to go into that. They correctly point out you typically don't have to go through that process again unless there's a new structure. This isn't a new structure, but we're using it in a way for which it was not approved, and doubling the adults using the road, I think, will create some congestion on this narrow dirt road that need to be addressed, that need to satisfy the International Fire Code requirements before we can move forward. And my last real point just has to do with the authority of the director. We pointed out that we've been unable to find any minutes that confirm that the interim director was approved by the city council is required by the code. It's our position that if she was never approved, then the actions that she's taken are not binding. I know that both the county and Finding Hope point to the Olms case. I don't know if I'm saying that right. But that case specifically has an exception for the person making the claim. So they get the fruits of their labors, I think it calls it. And we're not claiming that necessarily everything she's done is invalid, but we're claiming that if she's made these approvals here and hasn't been approved by the city council as required by the code, then it would be not enforceable.
Help me square that with kind of the notion of equity. A land use applicant, Finding Hope or any other, probably wouldn't delve into minutes to see whether an appointment has been made. They say, this is the person the county tells me to talk to and submit an application to. I've done that, I've gotten an approval, and I've gone months down a process, and turns out I have to start again and potentially wait for the county council to make an appointment that might take a month or two, and then, delay a project by 6 months more. I think that's why the ex officio officer doctrine exists, is to avoid that kind of inequity. So help me square that. I mean, I get the point of, we've made an argument, we're raising this issue, and it's potentially a very salient and proper issue to raise, but Finding Hope is somewhat innocent, and they didn't cause that misunderstanding or lack of appointment.
And I guess my response is you got to look at the fairness from both sides. I mean, every person who lives in Cache County should be at least to be entitled to rely on the code as it's written, and they should be able to believe that the county will enforce the code as it's written, and if that's not happening, it's not fair to them to be able to say, well, this person who wasn't approved properly made a decision, and it's going to impact you guys, and you're stuck with it even though it wasn't done properly.
And it seems like I could make the same argument the opposite way. If everyone in the county needs to talk to someone about land use and development, and the county says, here they are, and is it fair to say, you don't get to have any kind of code application or interpretation until the county leadership decides at some point to make the right appointment?
I think that's why the Olms case, the court recognized the officer doctrine, but then it made an exception for the person bringing the claim, because there doesn't need to be some way for somebody to make sure that the proper codes are followed. I mean, if there were no way to do that, then why would the county ever do what it was required? Because they could just say, well, it doesn't matter because everyone was relying on what we were doing, and there'd just be no possible way to enforce it. So yeah, that's why we're not saying that everything that she's done is improper, but if she wasn't properly approved, then the person bringing the claim is entitled to the fruit of their labors. I don't know if I'm using that right term, fruit of their something.
That was something like that from the case. Okay, that's a point is taken, well taken.
So, I mean, based on those arguments, we're asking you to overturn both the reasonable accommodation request and the zoning clearance.
Kind of a final question. You also suggested remand as well, and I believe there is the Moab case that talked about where there's not findings of fact, which you've argued there's not findings of fact sufficient, that the remedy is to send it back down for findings of fact. Is that appropriate here?
I don't know. Honestly, I did look into that, and there's not a whole lot out there.
There's not.
So, I mean, our position is that it should just be overturned because it wasn't done properly, and if they need to go file something new, I guess we'll deal with it then, but.
So your preference would be, the relief you're seeking is overturn the decision, and then if there's a new application made, then it's a new application.
Correct.
Okay, thank you. Mr. Crane?
Thank you, Mr. Patterson. I guess from the county's perspective, I'll just kind of highlight that I guess this case may be a little different than previous ones we've interacted with, in that it's pretty much a paper record. I mean, that applicant, Finding Hope, submitted their applications, the county reviewed them, rendered a written decision. We have copies of what was submitted, what those decisions were. It's not like you've had to go back and watch numerous hours of other hearings. So really everything's laid out before you, and the county's and both sides have presented their respective briefs and their respective arguments. So I don't know if I have a whole lot more to expound on than what's already been presented. I guess I would just highlight the fact that, as you're well aware, the standard review in this matter is on the appellants at this point. The burden is on them to show that the decision by the interim director in this case was arbitrary, capricious, or illegal. And obviously, substantial evidence is the standard there, and it's defined as evidence that's beyond a scintilla and the reasonable mind would accept as adequate to support a conclusion. And as you've already mentioned before as well, in your job here as the appeal authority, you are to determine the correctness of the land use authority's interpretation and application of the plain meaning of the land use regulations, and interpret and apply a land use regulation to favor a land use application unless the land use regulation plainly restricts that application. And I think it's been discussed numerous times here. The relevant county code at play is 17.16.050 Charlie. And I'm not going to read that all right now as well, right? But it talks through those different factors that need to be met, 1, 2, and 3 there. And in the decision that was issued by the interim director, she goes through each of those factors and cites to the evidence there and to support those determinations. And she specifically refers to the document, the reasonable accommodation application submitted by Finding Hope, and references the exhibits that were also attached to that, the 700 plus pages that were referenced there. So from the county's perspective, just trying to keep it as simple as possible. Essentially, hey, we have here's what the code says, here's what the applicant needs to provide, here's what they did provide that application. They asked for a reasonable accommodation for 16 individuals at this location. The county worked through that and I think can rely on the applicant, the information submitted by them in making its determination. I think everything was done properly in that regard. And again, we're just relying on evidence that was submitted as part of the brief and everything else along those regards. As far as some of the other issues at play, again, I think I've made the response in the respective briefs. I don't know if you have any other specific questions. I guess one thing I would highlight, at least the last point that's brought up when it comes to the interim director's authority. I know there's been arguments one way or another about whether or not that was proper or who should rely on or whatever. And I realize it's not part of the record today, but to just clarify everything, last night at the county council meeting, it was brought up, there was a specific vote taken to confirm Angie as the interim director, and that was backdated to the original February date of when she was initially presented to the county council by Executive Zook at the time. So that has been, I guess for all intents, my opinion would be that's essentially a moot point for purpose of today when it comes to that argument. One, I think I would rely on that, yeah, she's acting as an officer de facto for reasons you've discussed. But two, out of an abundance of caution, she has been voted on, consent has officially been given, and so that's where I leave that.
I did have a couple questions. You outlined the standard well there, and county's just applying the code. So on the code requirements, there is a kind of a submittal requirement for the application or a license issued by the Department of Human Services or Department of Health, some affidavits, and then a business license that says those should be submitted prior to the approval of the zoning clearance. So how do you, what's kind of the county's response about whether those things were taken care of or how they were taken care of?
From the county's perspective, it was taken care of through the conditional approval process. The way I would read the approval for, say, the zoning clearance and everything else was, hey, this is conditioned upon you getting the business license. There's language in there that, in my opinion, would support that. And so I would say that it is certainly proper to grant approval with conditions, one of those conditions being, okay, you gotta go get your business license, and then once you get that business license, then you're ready to rock and roll, essentially. As long as you meet all the other conditions or whatever else, the situation may determine.
Are you aware of any parking requirement standard for residential facilities?
Based on what was discussed earlier, I'm not aware of any specific standard articulated in code, no. I
think I have some other questions, but they'll probably be better directed towards Finding Hopes. So Anything else you want to share with me or have me consider?
Unless you have any other questions, that's essentially, like I said, the summary of where I'd be at.
Double check my notes, see if I had anything I wanted to. I would like to get your take on the issue I raised at the very beginning, the number, and what. I'm not sure. I was double checking here. I don't think I actually see the request is approved, but is there a specific finding related to that specific number, the 16 residents?
So I'd have to go back and double check, but my understanding would be from the actual zoning clearance approval, I would say no, there was not a specific request approving it was the zoning clearance granted approval for a residential living facility.
Right.
Did not dive into specific numbers of what was approved, not approved. That was the purpose for the reasonable accommodation request, and that specifically granted approval for the 16 people. I can.
I'm looking at, I'm not seeing a specific finding or discussion of that 16 number. It's kind of a general discussion of there are benefits and they need to do this. They need to have multiple residents in order to provide, an effective facility and effective treatment. They are disabled. The house can kind of hold them. They will provide or recover residents to disabled individuals. And based on the size, it would work. And then it just talks about it's approved for a 16-bed residential living facility.
Right there at the beginning, correct.
So is there a discussion of kind of what supports that number anywhere, or what's your take on that?
I guess my take on that would be the document speaks for itself essentially, right? So, but there is the reference, she does reference the supporting documentation submitted, and she specifically references the exhibits there as well. So I think ultimately, when we come down to say the request of 16, looking at that, is that reasonable, is that necessary? And it's approved, and the reliance is upon the documents that are submitted. I give an example in the brief as well from that one study as well. So,
okay. So I don't think I have any questions for you, but thank you for your presentation.
Thank you.
Mr. Biddulph?
Well, thank you, Mr. Patterson. Excited to be here. There's a lot that I could go into and talk about. I think probably the most effective way for me to use my time is just to maybe first ask you what questions. I can dive into the number 16. Is there any other questions that are burning?
Yes, and it relates to that number, but there's one of the arguments raised by the appellants is a lot of the studies or the documentation supports, critical mass of residents for therapy purposes, but doesn't really tie that to residential facilities, living, that type of facility. So can you look at something that says, yeah, you need at least, about 15 people, and then apply that to a residential facility? Like, how are those equating to each other?
Yeah, thank you. Finding Hope's response to that is simply, there is a document that does specifically talk about residential living facilities and says 8 or more. So that, I don't think that's argued, I think that's clear. The number of studies that have been conducted usually are not isolated to group therapy in the residential living facility realm. And I think the biggest purpose that is, being missed here is, why do these reasonable accommodations exist in the first place? It's so that these disabled individuals can live together, and it creates a therapeutic environment. And so when we're talking about group therapy, it really doesn't matter if we're sitting in a circle, if we're in an inpatient residential, inpatient rehab facility, or whether it's a sober living. The whole purpose and the reason that these facilities are granted reasonable accommodations is because it's a therapeutic environment. And just by living together, it is group therapy. And it creates a cohesive group. And so when you look at all of the studies and all of the documents, some do specifically reference, you know, inpatient treatment or sober living or just going to, say, an outpatient group therapy setting. Most of them don't. Most of them, it's just group therapy, because that's what all of them are. And so when you're talking about, okay, how are we going to create a therapeutic environment that is actually going to meet the therapeutic needs of these individuals, well, then we have to look at, okay, how do you receive the necessary therapeutic benefit with group therapy? Well, you have to have a group size that is sufficient enough. So I don't think that the exhibits need to expressly spell out, okay, in this type of group therapy, it's this number. The whole point is, it's group therapy.
So if I'm taking your argument correctly, it's essentially all residential facilities of this nature inherently involve therapy. So anything that does discuss therapy relates to this.
For sure.
Is that simplifying it down too much?
No, that's totally fine. It is therapy. And I've seen some confusion in the briefing of, oh, hold on a minute, Finding Hope said there isn't going to be, you know, therapy here or things of that nature. What we're specifically talking about is, okay, that's being transported over to the outpatient center for those that choose to be involved with that. And they can go and participate in, say, sit-down group talk therapy. But there's absolutely just a therapeutic environment. That's the whole reason for all of these facilities. It's the reason these cases get litigated. It's the reason for the Fair Housing Act as it applies to these. It's because it curbs isolation. It creates the therapeutic environment.
Is there some document that makes that tie? Or is it more just kind of a general, like, it's understood that this is what this facility is for?
It's just understood. The whole reason for this facility is because the group creates a therapeutic environment. Just living together with that support system, with the accountability, with how these homes run, it is group therapy.
So on the number more specifically, I mean, I think it seems like no one would argue that a number of 8 is clearly a reasonable accommodation. And we have that 8 or more. There's some, I think both of you pointed out, you and the county pointed to the discussion of like at least 15 or in that area. One of the cases that was cited talked about a similar facility, and basically the facility demonstrated that 6 residents wasn't sufficient for operations, for therapy, for financial reasons, all of those reasons. But the court still denied their accommodation or upheld the denial because they said, sure, you showed that 6 wasn't enough, but you didn't show that 12 was enough, and held it on that. So what's your response to that?
Well, so what that case says, pardon me, is that they didn't provide any evidence that it was therapeutically meaningful. And in this case, that is just not even remotely the case. We have provided evidence that it's therapeutically meaningful. And just to back up just a second, the problem with that case, we are in a different realm here. So every one of the cases that you're going to go and find is between the municipality and the applicant.
Yes.
And when that is the posture, when that is the dynamic on appeal, the question really is it necessary? Is it reasonable? Here, that's actually not the question. The question is, was the county's decision that it was reasonable and necessary, is that arbitrary, capricious, or illegal? And to be arbitrary or capricious, there has to be no evidence at all. It's a very high bar. There can't be any rational basis for the county or the municipality's actions. That's definitely not the case here. We're talking about a document that says 8 or more. We're talking about another document that says about 15, but not more than 20. That shows it wasn't arbitrary or capricious.
So, maybe I'll take it on hypothetical. It's, if I'm understanding you correctly, it's perhaps if the county was looking at this, if we were dealing with the director's decision and she was looking at whether you would actually provide enough evidence to hit that 16 number, maybe there's an argument there that you didn't provide that evidence. You would argue obviously that you did, but that would be the question there of like, did you show that you can get from 8 to 16? And that would be more in that lower realm. But in the posture we're in here now, where it's an appeal, the question isn't really, did you demonstrate that? More of, did you demonstrate enough that her decision has some basis? I think the substantial evidence standard is more than a scintilla of evidence to support it. Is that?
You got it nail on the head. I mean, if we were the appellants and it was us against the county here in this proceeding right now, then that's a very different discussion. And every one of those cases are relevant. And it really is diving deep into, hold on a minute, did we meet our burden? Did we show it was reasonable or necessary? That's just not the posture that we're here in. The posture that we're here in is, was the county deciding that the application demonstrated reasonableness and necessity? Is that arbitrary, capricious, or illegal? And it is just absolutely, unequivocally no. I do think that it's also worth pointing out, there's been a lot of talk of, well, how did you get to 16? I mean, for heaven's sakes, we could have asked for 30. That's what Utah code allows as far as capacity. We're way below that. That's Finding Hope looking at this and saying, okay, we have a 10-bedroom house. Most of the residents need to have individuals that they share bedrooms with. A few of them are going to be far enough along in their recovery and their, with their lengths of sobriety, and their recoveries will be in a place where they are capable of living in a room by themselves at this point. Not moving out of the house, but living, in a room by themselves. Well, there will be some that are at that point. There will be many that are not and that need to have a roommate. So how do we effectively curb isolation when we have a revolving door group? And I think I don't need to explain what a revolving door group is. I'm sure people hear that and say, oh my gosh, we're gonna have a transient center in our neighborhood and it's gonna be different people every week. That's not what that means. It simply means that as someone is graduating, someone else comes in. And sometimes, and Finding Hope, they have facilities all over. I've done many of these for them. We have one in Draper, or Sandy, that has 6. Why does it only have 6? Because it's a tiny house, and that's all that can reasonably be fit. We have one in Boise that has over 20, because it's actually, believe it or not, even bigger than this house. And so it is property by property. It is case specific. We have one in Logan City. It's 12. That's what that property should have. And so that is Finding Hope looking at it and saying, okay, with a revolving door group, what is the maximum, if you follow me there, that we can have and still have that critical mass to be able to actually deliver the therapeutic environment that these individuals require. But I do think it's very telling that Utah code would have allowed us to ask for 30, and we're a long ways off.
Did you, I don't recall, so please give me guidance if I've missed it. Did you present that notion of, pairing up people, sharing bedrooms, the therapeutic benefits? Was that presented to the county?
It's in the reasonable accommodation application.
Okay.
Yeah, we talk a lot about isolation. The whole way that the county determined for, and actually this is a really good segue into that as well. When we're talking about evidence, the applicant's assertions to the county, no question, that is evidence. We're not in a courtroom here. A municipality is allowed to say, okay, this is what has been represented to us, and we're gonna hold you to it. And that is what the approval of the reasonable accommodation says. It says you have to run this facility as you've represented to us that you will. And if you're gonna step outside that, you're gonna have to come back and ask for another reasonable accommodation. So when we're talking about, well, what evidence is being, submitted and what aspects of it, yes. I mean, for heaven's sakes, there's a big difference in that type of assertion and courtroom evidence. A county and municipality is allowed to rely on that. Another thing I think is important to point out is with a lot of the, as far as reasonableness is concerned, a lot of the allegations are asking the county to, they're asking the county to supplant conditions and requirements on the applicant that are just not required. I mean, take the International Fire Code, for example. It clearly says it doesn't apply unless there's a new structure being built or a structure is being relocated into the boundaries. Well, that obviously hasn't happened here. So it doesn't even apply. We did interestingly point out that the main appellant certainly would apply to him because there's a recent structure that was just built on his property. I don't think the county required any widening or different material to be put down on the road. So if the county were, for example, to enforce something like that against the applicant, it would be discrimination. It would totally be enforcing provisions in a selective way. So I do think that's important to point out, that when you look at all these different aspects, they just don't apply. When you look at the parking analysis, I think I don't need to spend a lot of time on that, but it says this use doesn't require 5 or more parking spaces. Just because we have more than 5 doesn't make a parking analysis required.
What would be your response? There was a discussion from the appellants regarding the kind of evidence of impact on adjacent properties and whether that was even addressed as part of your application to the county.
Well, I think that it's sufficient for us to talk about most of the residents don't have vehicles. Most of them are shuttled in and out. We certainly made representations that it's not going to increase the effect on the neighbors. The septic tank, I've heard that argument brought up. That's one of the conditions that we had to deal with. I can represent, we've already done that. We have the updated permit. It's the Bear River Health Department has totally decided that this house and this sewage system can accommodate that. And we've provided that to the county just recently as far as satisfying our conditions on the zoning clearance. So I think it's enough for us to make those representations of this is how this program will operate, and the county can rely on that. While you're looking at your notes, if I could make one more comment, the appellants, when he was up here just before, one statement that was made was striking to me. I wrote it down. It says, it needs to be difficult to increase capacity by this amount. I think that's the whole point of a reasonable accommodation application. You know, when you want to pile on all of these procedural mechanisms that don't even apply and say, well, hold on a minute, that's too easy for them. That's too easy for them. They need to do a parking analysis. The code doesn't require it, but they need to do one because it would make us feel better. Or, you know, the road needs to be widened. The International Fire Code section doesn't apply here, but that needs to happen because the barriers to entry need to be higher. That argument, that flavor, that's discrimination. You can't do that. You cannot impose additional hurdles on the applicant that are not required. You just can't do that.
So I have a question. It's not related to what you just said, so I do.
That's okay. Bounce
appreciate your
wherever we need
arguments.
to.
Regarding the code requirements, kind of segueing off of that, the requirements of those other licenses, there's at least two others, or an application or a license, and then a business license.
Yes.
And the requirement that those be in place, the code says shall provide or have those in place prior to granting a zoning clearance. How do you respond to that?
That is a catch-22. And I think you hit the nail on the head earlier when, because I've done this a lot of times, the state wants the city license before it will get into the process. It won't do it. I can represent, we called the clerk's office about the business license, and we were told, you can't get that. It has to go in this way. It's a catch-22. The county wants the zoning clearance and the reasonable accommodation before they'll give the business license. The state wants all of that before it will do its part. I think that, again, going back to equity and harmless error, if it were strictly applied, it would be an impossible burden. We would not be able to follow that. We can't get a business license before we even submit our application. And we can't get a state license before we get the county license. And so putting them in as conditions, I've seen municipality after municipality do it that way. We're obviously fine with it. We're happy to pay the fee. At the end of the day, a business license is well, I can tell you, when I called Lola here at the clerk's office, that's what she told me. She said, if I have the fire code people and they say yes, and I have the land development department and they say yes, you get your business license, but you don't get it until then. And we have that in writing. It's an impossible burden for us to meet, so attaching it as a condition makes total sense.
And your position would be that the county did make that a condition of your zoning clearance?
Absolutely. Yeah, we certainly see it that way. We didn't run out and move people in, and we won't until we get a business license and a state license, for that matter. As an interesting segue, we just had one of these homes approved in Logan. The hearing in front of the Logan Land Use Board was, it was several weeks ago. I can tell you it took that long after that process was approved to get the state license. Those individuals have just barely started moving in because now we have our city license, we have our state license, we have our approvals, now we are good to move in. This is no different.
And let's see if I had any other questions I wanted to ask. One question I do want to ask, and I probably should have asked the county this as well, but let's say I find, more just curious of procedurally. Let's say I find there was some essential finding of fact that wasn't made to support the decision. What should I do? Should I overturn it? Should I remand it? Obviously preference is I uphold the decision, but if I'm going to do something that's not that,
No question, our preference is that it's upheld. If not, it's absolutely a remand for the director to add additional findings of fact. I would say, based on where we are at right now, well, I mean, I'll just point to the approval. After reviewing the reasonable accommodation request with supporting documentation. And down below it directly references the over 700 pages of exhibits. In my mind, that is sufficient enough. I know that's not what you're asking me. That is sufficient enough. If for some reason you find that it's not, then remand is appropriate. To save on, I mean, I do think there's certainly an argument to save on taxpayer resources, to minimize the burden on the system, will be right in the same exact place. It's, again, one of those harmless error standards. If you were even to find that it's an error, we don't think it is. But if you were to find that it is, it's a harmless error standard, or it should be, because the county now, all the assertions, the direct evidence, I mean, what would it look like if she goes back and says, hey, Exhibit W, page this, says this. Exhibit M, or P, or whatever, says this. And that's good enough to show this. I mean, it just seems like totally unnecessary. I think that by citing the record, by citing the exhibits in general and saying that supports this, I think that's good enough.
okay. Anything else you want me to hear or take into consideration?
No, just that arbitrary, capricious, or illegal is a very high bar.
Thank you.
Very high bar. Thank you.
Mr. Jones?
I have a few points I'd like to hit. Do you want me to jump into it, or?
Please do.
Regarding the burden, I want to go to 17260B of the code. It says the appellant has the burden of showing the evidence and proving that the decision of the land use authority is arbitrary, capricious, parentheses, unsupported by evidence or facts of record, or illegal. It's our position that we've easily satisfied the several of those, including the capricious, because there's no evidence. I mean, no evidence showing that 16 is necessary, that 16 residents are necessary at this property to deny an equal housing opportunity. There's nothing out there at all. There's one, we have one document that says benefits start to accrue at 8 people. First of all, that's not 16. Second of all, I continue to question whether or not that counts as evidence that shows in this situation we need 8 people to live in this house. I mean, the evidence needs to apply to the house, not just to anyone in the country. And I think we need more evidence than somebody at some point wrote that 8 people was necessary. I mean, that's not evidence that I think can be applied to this situation very.
What would that evidence look like for this facility? Because they're not in operation, so they don't have any data they can show. So what evidence would that be to support what they're wanting?
It would need to be evidence showing that in the type of operation that they're running, or the type of groups that they're running, the type of therapy that they have, you need to have at least X amount of people live in a house to remove a housing barrier. And I don't think they've done that. They admit that there's a house in Draper that has 6 people. Well, why does 6 people remove a housing barrier at that situation, but not in this situation? I have no idea. It just doesn't address that at all. Instead, we just have these kind of studies that don't apply to this situation at all, and no evidence that supports the actual house that we're looking at.
How do you respond to the Finding Hope's Council's argument that the studies that do talk about, you know, the benefits of therapy and group size in therapy apply to essentially any group residential facility because those are by nature therapeutic?
Well, with all due respect to him, I think my argument would be that's him trying to introduce his own testimony as evidence. There's nothing in the documents that have been provided that state that. And the other response is therapeutic benefit is not the standard here. We don't need to prove, simply proving that something is therapeutically beneficial is not enough to prove that something is necessary. Finding Hope has to prove that fewer than 16 residents would deny an equal housing opportunity. Just because something might be therapeutically beneficial, that's not the same. And also that document they're trying to rely on states that, I don't know exactly what it says. It says around 15 people. It certainly doesn't show that 16 is necessary, or that 15 is necessary for that matter. But
Using the substantial evidence standard, which is very deferential to the county's decision, what's your position on that? So substantial evidence just says they can't have, as long as they had some evidence, you know, more than a scintilla that a reasonable mind would accept to support a conclusion, that's enough to support the decision. If we have documents that say, yes, there are benefits for this type of facility to have, you know, minimum of 8 and 15 to 20, and you want a range of that, how is that not substantial evidence to say, okay, all of those, you know, we kind of have a network of different studies that point to this number. Is that not substantial evidence for this allowance?
No, it's not, because the law clearly says they have to show that the amount they're requesting is necessary, and there's zero evidence that says 16 is necessary. The fact that they have some ranges out there that show that 16 might be beneficial in therapy settings, I mean, that doesn't show that 16 is necessary to afford them an equal housing opportunity.
And I guess I'm trying to make this distinction in my mind is, or maybe there isn't, but do they have to say that if they provide enough for the county to accept that 16 is a reasonable amount? Like if they have enough documents to say, you know, a little fuzzy circle of numbers, that is the range that this facility needs to be at to operate, you know, for the benefit of its disabled residents, to allow them to enjoy the same, you know, living conditions as non-disabled persons. It's in that range, and the county looks at that and says, okay, you get a number in that range. And then the appeal standard seems to be, can't the county do that? But on a challenge is, they don't need to have an exact number. Like, sorry, I'm not expressing this question well. I'm trying to tease out the two standards. It's their application. I could see maybe the county denying it, saying, you didn't tell us, show us where you got to 16. You don't do that, we're going to deny it. I've seen those cases. But now that we're past that decision point, is it enough for the county to say, they had enough to justify my decision, even if it wasn't perfect?
Well, let's just read the code. 17-1650, the decision shall be based on evidence of record, demonstrating that, number 2 is probably the most applicable, that but for the accommodation, one or more person will be denied an equal opportunity to enjoy housing within the community. There's nothing, zero, that's out there showing that but for 16 people, someone will be denied an equal opportunity. There's simply nothing there. And so when we go back to what our burden is, to show that something is capricious or unsupported by evidence of facts, we say, well, let's look at this. There's zero evidence showing that 16 is necessary, so therefore it has to be overturned.
How do you respond to Council for Finding Hope stated essentially that the county can, I'm paraphrasing this, so I apologize, but the county can rely on the submissions from a land use applicant and take those into consideration in making a land use decision.
I guess were you done?
Sorry, no, go ahead.
There's again nothing to support the argument that bare assertions are evidence. I mean, I don't know of anything that supports that. Just because they're claiming it doesn't mean it's evidence or true for that matter.
I don't know if you had a next point you wanted to hit, but I had some questions.
I've got a few, but go for it.
I was just curious, your response to the county's statement about the ratification vote on the interim director, or the appointment vote.
It's hard for me to respond to that without actually looking at the minutes. But I mean, if she was approved, then she would have authority to make decisions in the future, but not in the past.
Okay. And I guess another question. Their argument, Finding Hope in the counties, is that the decision was properly conditioned on meeting those other license requirements, those other submittal requirements. I know we kind of talked about that, but just having heard their arguments, what's your response to that?
Well, it's a similar argument to the arguments. Their arguments that there's proof. I mean, they say, for example, there's proof showing that it's necessary. They say here that the county's decision, addresses that issue, for example. But then you go look at it and it doesn't. There's nothing in the county's approval that says you have to go get a license. There just isn't.
I think those are my questions at the moment, so if you have more, please share.
Just a couple things I'll go through quickly. This claim that Utah code would have allowed for 30 residents, that's simply just not true. The code they're relying on says the minimum square footage you have to have somebody live there, and they're extrapolating that to say this is a maximum that's allowed, and that's a red herring that doesn't apply. Regarding the therapy thing, that group therapy is a clinical activity that's typically led by a licensed therapist. Just claiming that something is therapy because we say it is, again, there's no basis for that and nothing in the evidence to support that claim. And we also obviously disagree with the fact that we're trying to make things more difficult. We're not. We agree that people with disabilities are entitled to certain accommodations. But that doesn't mean you get whatever you want. It means you have to comply with the law, and we're saying that the law has not been complied with, and that's all we're asking for. And then the claim that it's an impossible standard to require licensing before the zoning clearance, I don't think that's true. I mean, in their opposition, Finding Hope made the assertion that it's impossible because you can't get. They made it sound as if you're required to get how do I say this? That you're required to get a license before you get the reasonable accommodation answer, and that's not true. The order should be you get the reasonable accommodation decision from the county, then you go and get your zoning clearance, then you go and get your license, and then you go and get your zoning clearance. I think that's perfectly doable. And I think I had one more point. I guess the last point I'll make again is that by making this approval, you're doubling the number of people that live on this road and in this small neighborhood. You're going from 4 what's allowed by the county to 16, which is a 400% increase, and also doubling the number of individuals that use this road and that live in the neighborhood. And we just don't think from a reasonable perspective that is reasonable, as it will clearly have a negative impact on the people living in the neighborhood. And using the nearby amenities.
So maybe I'll just ask one last question, kind of on that point.
Sure.
I mean, even aside from the Fair Housing Act and ADA, the county code says you can have these types of facilities in any residential unit in the county.
Yeah.
And then also provides a clear process for an accommodation, and it's almost anticipated that there would be a request for something along these lines. So I guess I'm a little struggling. The number of the increase, aside from whether there's evidence for it, but it seems like the impact is the county anticipates this will happen. Is that not how the county code reads?
They do anticipate this will happen. I would probably disagree if you said that they anticipated it would happen to this scale of a 400% increase. If you need a 1 or 2 or 3 person increase to give someone the same housing opportunities that others have, that's a different question than a 400% increase.
Okay. Okay. Anything else you would like to share?
I think that'll do it.
Okay, thank you very much. And thank you to all of the participants, council. I appreciate it very much. Just by way of kind of where we go from here, per county code, I have 15 business days to issue a written decision. I'll try to get it a little bit sooner than that. It depends on how life goes. And I'm sorry if I hit the 15 days. So I will not be issuing a decision today. I'll issue a written decision at a later point, and then depending on how I rule, whoever is adversely affected by that, you have a chance to appeal to district court. So, and that will be spelled out in the appeal decision as well. Thank you all for coming, and I will declare this hearing concluded.